But let's say, if we assume that they couldn't, just for the purpose of a hypothetical, then you do see that there's a distinction between someone who is trying to attack or change his conviction and someone who's trying to prevent a future conviction based on the same behavior.
I do, Your Honor, but Heck recognizes both a direct method and an indirect method. And so what the government would do would have you go back to the language in Prizer that says impugn the punishment. And so that's not what Heck said. Heck changed it and said we're worried about the fact of conviction or the duration of confinement.
Right, but I guess my hypothetical is trying to say that, you know, we have a situation in which it is not possible for a person who is seeking purely prospective relief to do anything about his prior relief. I mean, I appreciate your saying we don't want to take his word for it,
right.
and to the extent that possibility exists, we might still have a Heck problem. But in my hypothetical, there's nothing you can do about your past conviction, and what you're trying to do is go out and speak to people again in a way that does not subject you to future convictions, and you would like a declaration that says that.
Right, and I think the line again that the limiting principle we would say is that if you're trying to seek a facial declaration of unconstitutionality, then that would imply. Perhaps you could make a properly lodged as applied challenge and say, I want to do X, Y, and Z, and I think the law prohibits me from doing that, and that might be okay. And we see that in the law all the time.
Can I just ask you about your initial litany of doors that were available to Mr. Olivier? Were they all state forums, all state remedies that you discussed? Is there any other federal remedy? Because I think one of the things that's a little odd for me in this situation is that Heck really was about the intersection of two statutes, both of which were trying to give someone a federal remedy. And if we agree with you, this person ends up with no federal remedy. And that just seems odd,
right.
To reconcile those two statutes in a way that prevents their ability to have the kind of federal forum that Congress obviously wanted.
Well, two responses to that, Your Honor. So yes, my laundry list of things were state court remedies, and that's okay. We have the language from Muhammad v. Close that says that's what Heck is all about, is making plaintiffs resort to state court litigation is the language without resorting to 1983. So that's one. But then as a federal forum, the congressionally recognized federal forum is 1257 through a cert petition if they properly raised it in the criminal conviction. And as we say in the brief, perhaps there's a freestanding ex parte Young claim that somebody could bring. But Heck is all about using a civil tort statute to impugn the prior conviction, and that's what Heck says you can't do.